We're still talking about plea bargaining, though. This issue of Mohamed Abacha and, the federal government dismissing the charges against him. Some people think that, was that the right call?
Look, let's be honest from the beginning. Abacha's case is a political case.
So
Mohamed
which
Abacha...
brings us back to this issue of there's no political will to
No,
prosecute.
look. Abacha's son never stole any money. Let us have that clear in our mind.
He's charged with receiving...
His father, it is claimed, stole monies and transferred these monies into various accounts, including his son's account. Now, what you are charging his son for is for receiving. Receiving under the law is a criminal offense if you know that the source of the money is stolen money. But until you are able to prove it, you may not get a conviction. And what the federal government is saying is this: why do we have to go through the whole, terrain of prosecuting a man that we may not be able to convict? Because he never stole, and we have to prove that at the time the money was being paid into his account, he was aware that it was stolen money. It's a tall order. But now, internationally, we want to recover this money. Our aim is not to convict Mohammed. Our aim is to recover Nigerians' money that has been illegally transferred to accounts. And the American government is helping us. And the only person who knows where all these monies are is Mohammed. So why do we have to prosecute him and make him keep quiet rather than let him, be free so that he will give us information so that we'll be able to recover the loot?
There's also this suggestion for the creation of a court of appeal in every state, so we'll have state court of appeal. And this suggestion that the headship of the state judiciary will then go from the chief judge of the state to the president of the court of appeal that we've created in that state. Will that fly?
Look, this is not a new phenomenon. The 1963 Constitution that we were operating made provision for regional governments to have their own separate court of appeal. The only region then, out of the 4 regions in Nigeria, that took advantage of creating a court of appeal was the Western region. And they had a court of appeal. And it was successful because it minimized the number of cases that went to the Supreme Court. But to now recommend that where a state has a court of appeal, therefore the head of that court of appeal should be the head of the judiciary in the whole state is nonsense, with due respect. It cannot work because the high courts are different courts created under the Constitution, and a court of appeal, if created, will be a different court to be headed by a different person. A head of a court of appeal can never be the head of the judiciary in the state. It's a misnomer.
One other recommendation is also about the tenure of the Attorney General of the Federation and that of the states. The committee has proposed that they should have 6 years fixed tenure, and that, yes, we should separate the office of the Attorney General from that of the Minister of Justice, but there should be constitutional provisions on their tenure. Is that even something that we should be talking about?
No, not. You see, the only ministerial position today under the Constitution that is recognized under the Constitution is the position of an Attorney General.
Because it's specifically named in the Constitution.
In the Constitution. And the problem, as I've always said, is not in the tenure. It's in the fact that you are making a politician both an Attorney General, that is a professional, thing, and you are also joining him as a Minister for Justice. Now, when you have politics being joined with professionalism, you will always have problems. Because a professional, no matter how good he is, must be influenced by political considerations. Not only political consideration of his own, but by his party. So, it is correct that the position of an Attorney General should be distinct from that of a Minister for Justice. And that is what civilized countries are doing today. But the question of tenure, why do you need to give an Attorney General a tenure of 6 years? I don't see any reason for it. If you have a professional there tenure means nothing. Once you have a man that is independently minded, that is not prejudiced by political considerations, that is not going to be used by any political party in taking decisions, especially the decision in filing a nolli prosequi, then the question of tenure does not matter. It is the integrity of the man that matters.
One area that some people think that the conference didn't take into cognizance is this issue of the reform of the NJC and the excessive powers, alleged excessive powers of the CJN. Do you agree? I mean, I know we've talked about it, but do you agree that this is one area, especially with what's brewing in Rivers State, this is one area that they should have looked at?
My last program with you, I spoke extensively that we are now passing through a phase where the problems surrounding the NJC is going to be blown up. This is a commission that has, you know, a unitary form of system in a federal constitution. Never in the history of any country will you have a federating state where the judiciary will still form a unitary form of system, where the governance of the judiciary will be a unitary form of governance. That is the problem we have. The same constitution that says when you are appointing a chief justice of a state, the appointment must be made by the governor, subject to the recommendation of the NJC, to be approved after the appointment by the House. So you can see the tripartite way of appointing a CJ. Why do we need all this long touring-chi to appoint a CJ? Now, as I have said, the man who is recommending is not appointing. The man who is appointing still needs an approval. Now, when you want to discipline, who disciplines? I said it, that the Judicial Council cannot suspend a judge because they never appointed him. So these are the things the present national conference should look into and make sure that the judicial service system is really geared towards maintaining a system that will be devoid of controversies. I am happy there's a controversy starting now from this problem of Rivers State. And as I said in my last program with you, when that appeal gets to the Supreme Court, there will be drama. If one of the members of the Judicial Council appears on the panel that is going to hear the appeal, they will object to his presence. And that is when we will know we have a problem.
And just before we go, let's check out what's happening with the much talked about NBA elections slated for the 14th and 15th of July.
The Southwest Lawyers Forum, Egbe Amofin, met in Ibadan, the Oyo State capital, on Saturday, the 27th of July. Though the meeting was not open to journalists, Law Weekly gathered that the Egbe adopted their candidates for various positions. Law Weekly also gathered that even though two of the presidential candidates, Mrs. Funke Adekoya, SAN, and Mr. Dele Adesina, SAN, attended the meeting, the Egbe failed to adopt a presidential candidate for the NBA elections. The Midwest Forum also had a meeting on the same Saturday, but it's no longer news that the forum had long adopted its sole presidential candidate, Mr. Austin Alege, SAN.
We'll return next week with an interview session with one of the presidential candidates for the NBA elections. Be sure to send in your comments and questions to any of the addresses on the screen. And look out for these and past episodes of the program on our YouTube page. I am Shola Sheeli. Thank you for watching.